Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello everyone, welcome to another episode of All Things Policies. I am Kingshuk Saha, a researcher at the Takshashila Institution. Today I am joined by Anubhav Raj Shekhar, who is an assistant professor of law at the BML Munjal University in Delhi, NCR. He is currently on a sabbatical and is joining me from the University of Oxford, where he is researching South Asian society. In today's podcast, we shall be discussing one topic which speaks a lot about South Asian society, and particularly India. We are going to look at the controversial death penalty debate and how the debate has changed in recent time. Hello, Anubhav. It's great to have you in All Things Policy.
Hi, Kingshuk. Thank you for having me here.
The term capital has Latin root and meaning a punishment involving the loss of head or life, perhaps reflecting the use of beheading as a form of execution. Capital punishment has existed from millennia, as evident from ancient law code and Plato's famous rendition of Socrates' trial and execution by the democratic Athens in 399 BCE. In Indian context, Manusmriti and the Arthashastra have advocated for capital punishment to uphold the rule of law. Our present legal system, drawing from colonial British jurisprudence, has provision for capital punishment. More importantly, as we speak, there are 539 Indians who are on death row. In this light, allow me to ask, is death penalty a sign of civilized society? Should we have death penalty in 21st century?
So, thank you, Kingshuk, for your question. Allow me to start with some statistics to respond to your question. As of the end of 2022, the global trend is against death penalty, with roughly around 110 countries abolishing the death penalty and nearly 55 countries who still retain the death penalty, where of course, India and the US are two very successful democracies, but they still retain the death penalty. And even very recently, you have, in 2022 itself, you have countries including New Papua Guinea or Central African Republic, and I believe Zambia as well, who have done away or are close to abolishing the death penalty. In fact, yesterday only, Malaysia has done away with the provision of mandatory death penalty there. So that's what the global position is with regards to death penalty. In fact, even at the United Nations, if you see, last December, 125 countries passed a resolution against the death penalty, but India has voted in favor of it. So while globally the trend against abolition, in India, death penalty remains vastly popular. Is there a place for death penalty in civilized society? Well, you can argue both ways, of course, but it seems that the trend as far as criminal law is concerned or criminology is concerned, it seems that the trend is towards reformation rather than looking at punishment as simply from the perspective of retribution. But as I've just told you, that in India, the death penalty continues to be very popular.
Like just what you said, I'm reminded of there's a famous short story by Anton Chekhov, the famous Russian writer. So the bet, in which it start in a party and two-person discussing should there be death penalty or not. So one of the persons said when a person is given a life imprisonment, that is also like death. You are suffering each and every day. Other person said no, death penalty is better. So I think the debate will go on. Having said that, then I will ask you, why death penalty is so popular still?
Yes, actually, death penalty is popular because, you see, it is the easy answer. You have to carry out a very dramatic event whereby, you eliminate the criminal. And in some sense, then it becomes a zero-sum game. Like generally, it is given for homicide crimes where a person has killed another person, and therefore most people conceive it that only in those cases will a person be hanged or executed. Hanging would be a certain means of execution. So broadly speaking, they'll be executed. So because it is an easy answer, that's one way of looking at it. that you eliminate the person who has committed a certain crime which is considered to be brutal, and therefore it is seen as a zero sum game, and therefore public sort of supports it. But the underlying assumption is that it will have some deterrent effect on the other people who may think of doing this or something similar that the person would have done who has been executed, right? But there has been enough studies which have shown that a person does not do a mathematical calculation when they are going to commit a particular crime. And also the fact that globally, when you see countries which have abolished the death penalty, they did not see any rise in offenses, right? And therefore, to say that death penalty will have any deterrent effect, it seems to be flawed. The question is that if death penalty is not having a deterrent effect, then what are the other options, right? And why do you still have death penalty? So in that sense, I think the answer there is a difficult one, because you need to make structural changes, you need to provide education, you need to provide employment, which are the long term answers. And therefore the easy answer becomes death penalty or execution, right? And I think in some ways, which we do not realize this collectively, but I think in some ways the society is trying to hide its own failure or its own role in creating an individual who has perpetuated that particular crime. So society also does have a role in creation of a criminal, in creation of a particular crime. And when you are actually executing someone, in some sense you are executing a part of the society. So it is sort of a reflection, and this point needs to be discussed more often than we actually do. Yeah.
In what case is death penalty given in India? Who gets the death penalty? Like, in the sense, like, has there been any demographic study of these sentences in India?
So to answer your the first part of in what cases is death penalty given in India, there are 24 legislations in India under which you can be given the death penalty, which includes, of course, the Indian Penal Code, and then you have the Armed Forces Act, meaning the Air Force Act, the Army Act, Navy Act, and then more recently you also have the Anti-Hijacking Act of 2016, within POX also. Sexual offences is one area where the scope of death penalty has been widened, which meaning that if you commit the rape of a female who is less than 12 years old, you could be given the death penalty. So on and so forth. Now, coming to the second part of the question, who gets the death penalty in India? That's a very interesting question, and I believe some research on this front has been carried out by a very interesting initiative, which is housed at National University Delhi and it's now known as Project 39A. And the first death penalty report that they came up with, I think there was a discussion on this. And if I remember correctly, then there are roughly 75% of the people who were given the death penalty, they were economically vulnerable. And out of everyone who was given death penalty, around 35 to 40% people were sole earners. Even when you look at the social profile of the prisoners who were sentenced to death, you will see that I think 20% belong to the other backward classes, then around 25% were SC/ST, and around 35 or 30% were religious minorities. This is the entire, basically, I think the point that I'm trying to bring across is that most of the people who are on death row, they either belong to religious minorities or they are socially marginalized. And therefore, this becomes an even more discussion to have, that who are the people who are on death row, right? Are they able to access the justice system? Do they have the resources to access the justice system? Is identity at play? How does the legal system work? It's sort of a disadvantage rather than an advantage in terms of them having to put up a cogent and strong defense in their own favor, right? So these are some questions that we need to look at, and I think the standing of a person, be it financial or social standing, plays a huge role in deciding their prospects with the legal system.
I think what you said, it is applicable not only for the death penalty, but if you see the wider context of in Indian legal system and the justice delivery mechanism, because
Yeah,
like this is a major challenge. Like, I agree with you. So what are the options that a person has after they have been awarded death penalty?
so I think there'll be a slightly legal answer. to that question, because now we're looking into what happens. I'll just sort of explain, give a broad overview of how exactly the procedure works. So generally what will happen is that the death penalty, so basically first a person is convicted, right, of a particular charge, of a particular offense, that where the court says that you have been found guilty of this particular offense. After that, as per the law, there is supposed to be a separate sentence hearing. Sentence hearing meaning that you need to discuss what is the exact quantum of punishment that a person is supposed to be given, right? In that sentence hearing, the person is generally told that you have of course, they will only be on death row if they are awarded the death penalty. So they'll be told that, because the charges have been proved and after making due consideration, it has been decided that you are handed over the death penalty. Now, this is the moment after conviction where the person starts to being on death row. Once the trial court has told them that you're convicted and you're sentenced to death. After this, it is not automatic that the person, of course, is executed. The person has a few options. And more importantly, firstly, the High Court has to make a confirmation of the decision given by the Session Court. So the decision of the Session Court will automatically go to the High Court for confirmation, where the High Court has to say that yes, this decision has been confirmed and you can go ahead with the execution, or the person who has been awarded can go and file for further appeals under the law that are available. So generally then the person has mechanisms to approach after the High Court has given its decision. The person can further, after the High Court, they can go to the Supreme Court of India, right? They can go on. There are several articles actually under which the person can go to the Supreme Court, and the Supreme Court will hear the matter and they will provide a decision on the same, right, in the appeal. And after the appeal has been heard and decided by the Supreme Court, a person can also go ahead against the appeal and file a review petition within the Supreme Court. So, of course, the review petition will be decided by the court itself. And then, even if you're not satisfied with the decision of the review petition, you can, on very narrow ground, you can file for a curative petition, right? So, this goes on until the curative petition. And once the curative petition has also been decided, that's why you would have, in several death penalty cases, you will hear that, there is prolonged processes that have been followed on. And then after the court has given its decision, the final decision, it is not that that is the end of the road for a death penalty convict. A convict can then go and approach the executive, and they can file a request under Article 72 and 161 of the Constitution, where they can approach the governor or the president. And then let's say in the case of the president, the Home Ministry will advise the president, and the president is bound by the decision of the Home Ministry. So the Home Ministry eventually the president will eventually give his decision, and even the decision of the president can be taken to the court, and a writ could be filed after the decision has been given by the president in terms of pardoning, whether they will exercise the pardoning power or not in a particular case. And you can go and approach the Supreme Court and petition and say that, the certain supervening circumstances may not have been taken into consideration while disposing the request for pardon. So that is the options that are available with the person after, they have been awarded the death sentence by the Session Court. Yeah.
So it seems it's a fairly long process, and I think it will take quite some time.
Yes, it is, in fact, a very long time. And that question, allows me to, can I just take a moment to tell you exactly how long there has been a study, in fact, once again, which was carried out by National University Delhi, and they found that the median duration for these proceedings at several levels, they conducted a study to understand the median duration at 4 levels, which was the confirmation proceeding at High Court, then appeal and related proceedings at Supreme Court, and then the mercy petitions, and after that the post mercy petitions, right? Mercy petition meaning with the executive, and the post mercy petition proceeding meaning at the High Court and the Supreme Court. So at the High Court, the median duration for confirmation proceeding is 44 months, and the longest duration it has taken is 172 months. So 44 months is nearly 4 years. Then the next level, at the appeal stage in the Supreme Court, it's 70 months, and which means like 70 months is roughly over 5 years and slightly less than 6 years. And the longest is 298 months. Then at the mercy petition level, the median duration is 148 months. And at the post mercy proceedings, it's 192 months at the High Court and Supreme Court. So you can imagine that for how many years these proceedings sort of keep going, and the person is on death row, which gives rise to a thing called death row phenomenon, whereby a person continues to live each day thinking that any day could be last day, right? And it has grave psychological impact, which we are at a very nascent stage to understand very honestly. But there's growing consensus when lawyers are working alongside psychologists and psychiatrists that the death row phenomena severely impacts the mental condition of the people who are facing the death penalty.
Stay tuned to All Things Policy. We'll be right back after a short commercial break.
Okay, Anubhav, next, how has the death penalty framework evolved in India since independence? Like, how does the court decide in which case death penalty is given?
Okay, that answer is slightly long, in fact, because there have been a lot of development in the death penalty jurisprudence in India. Before the 1973 CRPC came into picture, we had the 1898 CRPC, which said that if in a case where death penalty is prescribed, if the judge gives any other punishment, they'll have to give special reasons for why they have given any other punishment than the death penalty. But after independence, this position had changed, and the position that was brought in was that if you are giving the death penalty, then you'll have to give special reasons for why death penalty has been given to a particular person. Right now, even though the word special reasons were given, there were no specific guidelines on how to decide these special reasons. Right, that how do you sort of engage into a standard of deciding that yes, this is the threshold after which particular case becomes these are special reasons, and that it is not. So, and constitutionality of death penalty was also challenged 1973. But eventually in Bachchan Singh in 1980, that is to just give you a shorter answer and sort of skipping a number of years. Bachchan Singh versus State of Punjab in 1980 is the judgment which sort of changes the death penalty jurisprudence in India, whereby for the first time it gives a standard as to how it is to be decided whether a particular person must be hanged or not. And it is a very popular statement you will often hear is that death penalty is only to be given in the rarest of the rare cases, right? But that's just the first half of it, actually. The entire quote is rarest of the rare case where all other options are unquestioningly foreclosed. So the second half is as important as the first half, right? Whereby now the question is that how do you decide what is the rarest of the rare case, right? So what is the standard again? How do you further break it down? So the court said that to decide whether a case is a rarest of the rare case or not, you have to look into two parts. First is the mitigating circumstances, and the second is the aggravating circumstances. In mitigating circumstances, what you need to look at is whether what are those circumstances which sort of go in favor of the criminal and reduce the quantum of punishment, right? For example, the age, if they're too young, if they're too old, if they're too frail, what is the mental capacity of the person, right? These are mitigating circumstances. You can also take into consideration, now it has evolved further in different cases, what are mitigating circumstances, like if there's too much delay in deciding their plea for pardon, so on and so forth. And aggravating circumstances are what goes against the person, right? And that has been a very controversial terrain, that whether you focus on the crime or the criminal. And after Bachchan Singh doctrine, which we are speaking about, there's another case of Machi Singh, which came in 1983, which said that you have to look into what shocks the conscience of the society, which means that public opinion had a huge role to play. And this is where it becomes really problematic. that how do you decide what shocks the conscience of the society? Are judges to be governed by what the public thinks, right? Because there's been a huge debate around that, whether, and we know that we do not have jury trials for a reason. Judges are supposed to stay away from news, media, and such engagements for a reason, right? So they are not affected by these. And then there's this new doctrine that has come where which says that even public opinion, in some sense, right? I mean, the word, how do you decide what shocks the conscience? For that, you have to look at the public, right? So the Matching Singh doctrine was there. But as far as Bachchan Singh is concerned, I was talking about the second half, where it says that it is not just about which is the rarest of the rare case, but also about the second half, which is when all other options are unquestioningly foreclosed. The term used is unquestioningly foreclosed, meaning that there is no other option but the death penalty. And this becomes problematic because how do you decide, right, that the person has no chance of reformation? Let's say another example would be that, let's say the proceedings go to the high court, and let's say 1% dissent. Let's say there's a division bench which has to confirm, division bench meaning two judges. Let's say one dissents. Then what happens is that it goes to a third judge, and whatever is the call of the third judge will be the decision. Now, in this case, let's say two judges say yes, death penalty should be awarded, and one judge dissents. Does it mean that it is unquestionable? Because one judge has at least raised a question, right? So it's no longer unquestionable. It is certainly questionable. And therefore, although this doctrine has evolved, and that is the current framework that we are following, it continues to be fairly contested in terms of how the doctrine should look like. Yeah.
Since India has a system to award death penalty in India, is it a robust system? Or do you feel there are some challenges in this system? So some of that need to be amended and make the system more robust.
That is what I was actually alluding to towards the end of the second answer. And it is far from perfect. I think there can be no system which is perfect in terms of awarding the death penalty. And a number of challenges have been, recognized. Firstly, simply in terms of resources. I mean, you can have a look at the file and say these are the aggravating circumstances. Let's say a person has brutally committed a murder. Further, they have done, like, let's say 500 pieces of particular body, and you'll say, oh, this is gruesome, and therefore that becomes an aggravating circumstance, but can be considered to be an aggravating circumstance. But how do you look at the file and talk about the mitigating circumstances? Because simply looking at the file will not tell you the psychological abuse that a person has faced as a child. I'm just giving an example, right? Or what is the background, what are the past experiences of an individual which has sort of made that person into the person they have become, right? What is the socioeconomic profile? For that, you need resources to make a complete profile, to go to the village the person comes from, to engage with the people, to where they went to school, their friends, right? And I think there's a lack of resources. In fact, in a 2019 judgment in Khushvinder Singh versus State of Punjab, the Supreme Court confirmed death penalty for a person and observed that there are no mitigating circumstances that have been recorded, and still went on to confirm it, which clearly makes it more concerning. Second is, of course, the Machi Singh doctrine, where, I mean, of course, Machi Singh has been in several subsequent cases. It has been said that, you have to look at the Machi Singh doctrine is problematic. The trial courts, which are the first, which are the starting point for any death row inmate, because that is the court which awards the death penalty for the first time. The Machi doctrine remains fairly popular at that stage, and there have been studies to show that as well. The third problem is that how do you balance out the mitigating and the aggravating circumstances, right? The Bachchan Singh doctrine is still not very clear about that. So it sort of goes against, it gives wide discretion and sort of goes against the convict. I think, yeah, while there are several other, but in the interest of time, I think I'm going to limit myself by highlighting those 3 points. Yeah.
Okay, so what are the recent debate in death penalty jurisprudence in India? If you can just briefly.
Yes. I think that's a very, very interesting question, because while the Bachchan Singh doctrine is also being looked into by the Supreme Court, I would like to speak specifically about one particular public interest litigation which is being heard, and that relates to the method of executing a person, right? The question is that whether hanging as a means of executing a person in India, is it too inhumane, and whether there is another way of hanging which is more human, right? And I'm quite certain that there has been an earlier law commission report which said that we should go ahead with lethal injection rather than hanging, but there were no legislative changes that were brought, and hanging has continued. Although I must mention that there are a couple of acts, the acts that govern the armed forces, that shooting is also permissible as a method of execution. But hanging traditionally has been followed in India. Traditionally, in the sense legally, it has been followed in India. But the point that I want to make is that I think before we adopt any other method, we need to also discuss the other methods that are available and whether they really help at all. And there have been studies that have been looked at in the US, because this entire debate, in my opinion, is coming from the US, where the Constitution says that there cannot be any cruel or unusual punishment. And that is precisely the reason why they have continuously changed their modes or added more modes of execution. So a study which was done in I think 2014, it found that electrocution, there were 2% of the cases out of the 4,300 executions until 2014 that were carried through execution. 2% of the executions were botched, which meant it did not go through as they were supposed to go. Lethal gas, 5.4% of the cases were botched. A lethal injection is the highest rate of botched execution, that is 7.12, right? So the idea that any particular sort of punishment would be more human, or there is, I'll give you examples. Let's say I'll give you two cases. In Jimmy Lee Gray's case, where asphyxiation was used in 1983, officials had to clear the room 8 minutes after the gas was released, when Gray's desperate gasp for air repulsed the witnesses. His attorney criticized state officials for clearing the room when the inmate was still alive. It was said that his defense attorney, David Buck, he said that Jimmy Lee Gray died banging his head against the steel pole in the gas chamber while reporters counted his moans, 11 according to the Associated Press, right? So people have died banging their heads against steel poles. And one last example I would give would be that of electrocution, which is of Frank J. Coppola in 1982. And it was reported that although no media representative witnessed the execution and no details were ever released by the Virginia Department of Corrections, an attorney who was present later stated that it took 255-second jolts of electricity to kill Coppola. The second jolt produces the odor and sizzling sound of burning flesh, and Coppola's head and leg caught fire. So the other mechanisms that are being talked about, be it electrocution or asphyxiation, they are equally inhumane. And the point that we need to recognize, and I'll close it with this, that the death sentence in itself is arbitrary, unusual, and cruel, and it starts at the point at which a convict is sentenced to death. And that is where it becomes unusual and cruel, rather than the simple act of execution, which is the final point at which you are which is a matter of theatrics. It's actually you are relieving a person, because a number of inmates have said that they would rather be executed than continue to be on death.
Thank you so much, Anubhav, for your insight. And with this, we'll end today's podcast.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.